Coming up next on Arizona Horizon, Maricopa County Sheriff Joe Arpaio is referred for criminal charges. A former U.S. Attorney for Arizona explains what it means legally. And we'll look at the original court case that led to the sheriff's current troubles. That's next on Arizona Horizon.
Arizona Horizon is made possible by contributions from the Friends of Arizona PBS, members of your PBS station. Thank you.
Good evening and welcome to Arizona Horizon. I'm Ted Simons. Several dozen protesters gathered today in downtown Phoenix to demonstrate against Maricopa County Sheriff Joe Arpaio, who's been referred for criminal charges in a racial profiling case. The midday protest began on Central Avenue, with the march ending a few blocks away outside the U.S. Attorney's office. Among those demonstrating, a young woman who was detained by sheriff's deputies during a workplace raid.
So I was happy that they were finally going to take this into consideration and actually press charges on this man who's been harming many families. Not just myself, but many families have been harmed by him emotionally and mentally.
What we want is for Sheriff Arpaio to go to jail and take his policies with him. He's now ushered an era of abuse towards undocumented and Latino communities. We want him gone and we want his policies gone.
Today's protest follows U.S. Federal Judge Murray Snow's request that the U.S. Attorney for Arizona file criminal charges against Sheriff Arpaio for repeatedly ignoring the judge's orders in a racial profiling case. Joining us now is former U.S. Attorney for Arizona Paul Charlton, now a managing partner with Steptoe and Johnson. Good to see you. Thanks so much for joining us. We appreciate it.
Thanks for
having me. Got a lot of questions for you. A lot of folks are a little confused on the edges of this thing because it's unusual in a variety of ways, which we'll talk about. What did Federal Judge Murray Snow exactly do?
We know from having watched this case over a period of time that everyone, including Joe Arpaio, his lawyers, agree that they were in contempt of Judge Murray Snow's order to stop violating the civil rights of individuals here in this county. What the judge found, what everyone agreed to, was they violated those orders, but what's new is that Judge Snow has found that not only did they violate the orders, they did so intentionally, and that there is probable cause, and Ted, that's a term of art in criminal law, that there is probable cause to believe that they committed a crime of criminal contempt, and he's now referred the matter to the U.S. Attorney's Office. Think of it as a formal invitation to the U.S. Attorney's Office to prosecute Joe Arpaio and others for criminal contempt.
I was going to say, when people hear referred for criminal prosecution, what does that mean?
It gives the U.S. Attorney's Office license to go forward with the prosecution. The judge has found probable cause, the judge has found a crime, and now he's invited the U.S. Attorney's Office to initiate prosecution against Joe Arpaio and others for criminally violating the orders of Judge Snow.
It sounds like there are three areas in particular Judge Snow wants focused, or at least he focused on and mentioned in the referral. Talk to us about those.
But Judge Snow found that Joe Arpaio and others violated his order from 2011. Stop violating the rights of others here in this county. Joe Arpaio violated that order, continued to violate rights, and Judge Snow has said that you are in contempt. He failed to turn over information relating to an investigation conducted by a man by the name of Montgomery in the northwestern part of the United States, an unusual and peculiar investigation about which we don't fully understand yet publicly what all of those facts were. And there were internal investigations that were supposed to have been taking place. They were supposed to have been fair and objective. The judge found that they weren't fair and objective, that they were driven towards a predetermined outcome, one that would be beneficial to the county sheriff's office and not an honest outcome.
Failing to preserve records in the case, was that mentioned as well?
It was, because some of the records that were supposed to be preserved as it related to Mr. Montgomery, other parts of the investigation were not handled in the right way. There were a number of tapes that were supposed to have been notified or let the monitor know about that they failed to notify the monitor about in this case.
The case has been referred to U.S. Attorney for Arizona, but could it go to the Department of Justice, like the Special Integrity Unit or something? I mean, do we know exactly where this is going to wind up?
I think we can say for certain that there will be a prosecution. The only question really is who is going to be sitting at the prosecution table. Will it be the U.S. Attorney for Arizona and his assistants? Will it be the Department of Justice and their Public Integrity section, or perhaps some other district, some other federal prosecution office that's invited in to assist? Even if the U.S. Attorney's Office, Ted, or the Department of Justice decline to prosecute this matter, the judge, or the judge that Judge Snow's referred this to, Judge Bolton, can make a decision that she wishes for another individual to take that prosecution and go forward.
Special prosecutor.
Precisely.
Do you think it's likely, or do you think the U.S. Attorney's Office will just go ahead and say, we've got this one?
I think there will be some agency within the Department of Justice that will go forward with this prosecution.
So, if it proceeds, are we talking a jury trial? Are we talking some other form of adjudication? What's going on here?
There is the right to a jury trial. Joe Arpaio's lawyer has already said that he's going to request a jury trial. And in every other aspect, although the origins, the birth of this prosecution is very unusual, Ted. This came from the court as opposed to a law enforcement agency making a referral to the U.S. Attorney's Office. But in every other aspect, this case is going to be very much like any other criminal prosecution, which is to say that defense attorneys will approach the U.S. Attorney and ask that they be heard before a charging decision is made, that there will be, if appropriate, discussions about a pre-charging plea agreement, that there can even be after charging discussions about a plea agreement. That's like any other case. It's like any other prosecution, and I think we can expect to see the same here.
Will we see the U.S. Attorney's Office say, yes, we'll take it, then he's charged? What kind of timeline do we have here? What kind of order is followed?
There is no set timeline, but I think we can watch through the public filings the decision-making process about who will be prosecuting this case. As I say, I don't think there's any doubt that there will be a prosecution here. The judge used a term of art in his most recent order on the 19th of August. The judge said there is probable cause to believe that offenses occurred here, that criminal offenses occurred here. And as you know, Ted, that is the term, that is the phrase, that is the burden of proof the judges have to make an independent determination of before allowing a prosecution to go forward. That's what's happened here. I think we're going to see a prosecution. The only question is what happens next.
And the idea of intent, that differentiates civil from criminal?
In civil contempt, all we're trying to do is to correct bad behavior. The judge says, I'll fine you so many dollars per day until you agree to follow my order. Here, this isn't coercive. This is punishment when you're looking at criminal contempt. This says you've already done wrong. Now we are going to seek a punishment for that wrongdoing.
What kind of punishment are we looking at here?
That's a very good question. And there are going to be a lot of legal scholars trying to wrestle with that. There is a statute that makes a maximum of 6 months. There are other statutes that can allow for greater than 6 months. This will be in large terms determined by the prosecuting agency that goes forward with this case and the judge at the end of the day who determines in the event of a conviction what the appropriate sentence ought to be.
Arpaio Chief Deputy Jerry Sheridan also referred here, ignoring court orders, misrepresenting court orders to subordinates, numerous false statements under oath. Will they both be tried in a parallel line? How does that work? There are two others, by the way, including Arpaio's attorney, who are also referred here as well. Do they all go off in separate directions in the court system? How does that work?
Those are appropriate motions that are sometimes made. Michelle Iafrate, Joe Arpaio's lawyer, Captain Bailey, one of the subordinates who worked under Chief Sheridan. Those individuals may seek a separate trial. There may be tactical reasons that would cause their lawyers to seek a separate trial. That's all going to be part of the motion practice that we're going to see here in the future.
Could be tactical reasons for them all to accept a plea.
There could be. We'll have to see. As I say, although the origins of this case are extraordinary, frankly disappointing, because we never want to see the head of a law enforcement agency found by probable cause to have committed a crime, and that's what we have here. In every other aspect, this case is going to be like any other criminal prosecution.
A couple of quotes here from Judge Snow. Lied to my face, he said of Arpaio. He wants him treated like any other citizen of Maricopa County, a history of obfuscation and subversion of this court's order. I mean, it sounds like he had enough.
There can't be any doubt as to how it is Judge Snow views Joe Arpaio, Chief Sheridan, Captain Bailey, and Michelle Iafrate. And so for good cause, he has asked that another judge hear this prosecution. That judge, Judge Bolton, very well respected, very experienced, very fair judge, will be making the determination at the end of the day as to how this case proceeds once the prosecution is brought.
Arpaio's attorney Mel McDonald said he was surprised, considering Arpaio's age, his apologies for disrespecting the court's order, the thousands of hours that the sheriff, he says, has been tallied up trying to comply with the order, all brought up by Mel McDonald. What do you think of that line of reasoning?
Well, I think Mel McDonald is doing his job. Those are all mitigating factors. Clearly, Judge Snow considered those factors. He has been nothing if not very careful and very methodical in his review of the facts and the arguments, and has come to the conclusion last Friday that there is probable cause to believe that a crime occurred here.
And indeed, another Snow quote here is that Arpaio is party to the lawsuit, not subordinates. I mean, he wants to make sure that everyone knows this is about Joe Arpaio, correct?
It is, and I don't think that we can let go of the idea and the notion, because it's an important one for we, the citizens, to remember, that this is the head of one of the largest law enforcement agencies in the country, now found by probable cause to have committed a crime. I think that's one of the reasons that Judge Snow has been so very careful before arriving at this order. Remember, this case began in 2008. The preliminary order was in 2011. It has been many years since this case began, and you're going to hear about that from your next guests.
Mm-hmm.
This has been a very slow evolution, or if you wish, devolution of the facts, and the discovery now has shown that Joe Arpaio is meriting prosecution.
Last question, you referred to this earlier. How unusual is all of this?
In my 16 years as a federal prosecutor, in my 10 years in private practice, I have never seen in this state a federal judge refer anyone for criminal prosecution on contempt. I have never heard of anywhere in the country the head of a law enforcement agency referred for criminal prosecution. That is the double-edged sword of this referral. It is a good thing that we are now reviewing the facts and understanding exactly what it is that Joe Arpaio did. It is a good thing that this rarely, if ever, happens in our country.
And the next thing we look for is what?
Well, we'll have to see who it is that's going to be sitting at the prosecution table, and then we'll have to see how it is this case is charged, because you'll know from the judge's order that it's not just the criminal contempt, but the judge made very clear his invitation to consider perjury charges, among other charges. So how it is Joe Arpaio and others are charged is something we'll have to pay attention to in the future as well.
All right, good information. Good to have you here. Thanks for joining us.
Thanks for having me, Ted.
Joe Arpaio's referral for criminal charges stems from the Melendrez case, a 2007 class action lawsuit against the sheriff's office for unlawful racial profiling of Hispanics during immigration sweeps and traffic stops. Here to talk about the Melendrez case is Terry Green Sterling, a journalist and writer in residence at ASU's Walter Cronkite School of Journalism and Mass Communication, and Jude Joffe-Block of KJZZ Radio. Good to have you both here. Thanks for joining us. Let's talk about this case that as we just talked about with Paul Charles. This goes back quite a ways, 2007, 2008. What got all this started?
Well, at the root of it was I think, an intense fear among many Arizonans of immigrants. And what happened in 2007, 2006, 2006 and 2007 was Arpaio was becoming more and more interested in enforcing immigration because the laws were changing. A, Arizona state laws were changing, and B, his constituency was asking him to do it. And the more he did it, the more publicity he got and the more votes. So that's what started us off. On the other side, you have people of color in Arizona who have historically been discriminated against in Arizona, who finally took a stand in 2007 and 2008 and initiated this historic, intensely dramatic court case that is hardly dry.
2007, who filed this class action lawsuit on behalf of whom?
Well, the case begins with Manuel de Jesus Ortega Melendres, who was at a church worksite area that had been set up for day laborers to be able to get picked up for jobs. And there had been a citizen's complaint. There was a lot of tension. It was a day labor center at a church in Cave Creek, and there was some community tension over whether this day labor center should exist. And the sheriff's deputies were asked to investigate what was going on, and they ended up doing a sting operation and pulling over a vehicle. It turned out that Mr. Melendres actually was a legal immigrant, and he was a tourist, and he had the right paperwork to be in the country. He ended up filing a suit because he was detained for hours. It seemed the sheriff's deputies assumed he was undocumented. And he spent hours, he was cuffed very tightly. He had a bad wrist, and he was in a lot of pain and treated very badly. And so he filed this lawsuit, and it later became a class action when other Latinos who actually were US citizens complained about being detained during immigration sweeps and other kinds of traffic stops.
And two of those were siblings, I believe, from Chicago. One of another person who was detained was an assistant for then Mayor Phil Gordon, correct?
That's right. That's right. There were a lot of really fascinating cases, and again, they were American citizens for the most part who were detained, and they said humiliated. Obviously detained, they said because of the color of their skin. As the sheriffs had ordered these immigration-themed traffic stops.
Yes. So the judge orders training changes, procedural changes, like radio in to explain why you're stopping this car before you stop the car. Sheriff's office does what?
Well, let me back up, because even before that, those orders came in 2013 after the conclusion of the trial in this case.
We had a 2011 situation.
There was a 2011 order that's really critical to understanding the contempt of court issue, because in 2011, what happened was, and let me add that even before 2011, there were already issues with the sheriff's lawyers getting in trouble for not turning over certain documents that were owed in the discovery process. So there was, even before we get into this iteration, there were issues from the get-go of withholding documentation that the judge wound up sanctioning the sheriff's office for even before the trial. But back to 2011, that's when Judge Snow makes his first really big order in the case, and he says that he wants it to go to trial to decide whether the sheriff's office was discriminating against Latinos. But before that, he knows right now that he can rule on another question, which is whether the sheriffs have the authority to do immigration stops and whether they can detain people only on the suspicion that they're in the country illegally when there's no other state-related criminal charges. And so in 2011, the judge makes this ruling: we're going to go forward with a trial, but in the meantime, you need to stop making immigration arrests. As a local state agency, you don't have the authority to make these kinds of stops. That's for the federal government. And earlier, the sheriff's office did have a partnership with ICE where they did have that authority, but that had not been renewed at this point. And so the judge was trying to say, you can't do those kinds of immigration arrests anymore. You can't turn someone over to ICE who you find just because you think they're undocumented.
Which leads then again to 2013, when we have all this monitoring supposed to be going on, and all the changes and procedural changes and all sorts of things. Again, Sheriff's Department response to all of this was?
Right. Well, the Sheriff's Department, we don't find out until later that this is going on, but the Sheriff's Department has in fact been enforcing immigration when it should not have done, when there was no state crime involved. And that went counter to the judge's very firm orders. So that's a huge violation, and the judge ruled that, well. So, and then we go to 2013, all sorts of things happen. In 2012, there's a trial. In 2013, Arpaio, the judge rules that Arpaio had indeed, and his department had indeed racially profiled Latino drivers and their passengers. And my gosh, That's a huge amount of our population, right? That's a very huge amount of our population. So then things get a little bit convoluted because the sheriff's office begins to get involved in some investigations that the judge doesn't know about.
Regarding the judge.
Regarding the judge, with a kind of really convoluted conspiracy theory that involves the plaintiff lawyers, the judge, and who's the third person?
The Justice Department.
And the Justice Department.
Who meanwhile had begun its own investigation and case against the sheriff's office.
So straight out of Breitbart News.
So, okay, so so now we've kind of moved forward from where this all began.
Right.
Through it all, and we haven't got too much time here left, but we wanted to kind of figure out where this all started. It's basically traffic stops, immigration raids, the idea of the judge saying knock it off, and Arpaio's people allegedly still doing it, and according to the judge, not only still doing that, but quote-unquote lying directly to his face. Has the sheriff's department ever shown remorse, apologies? I understand he's apologized.
Yes, there was a day in court during the contempt hearing where the sheriff said, was quite contrite and did make that clear, and his lawyer had a very contrite mode when he was asking for no criminal contempt charges. But here we are.
All right, we got to stop it right there. My goodness, we could do the whole show on this whole thing, but at least we got an idea of where it all started. Now we know where it is. We'll see where it goes. Good to have you both here. Thanks for joining us.
Here.
That's it for now. I'm Ted Simons. Thank you so much for joining us. You have a great evening.
Arizona Horizon is made possible by contributions from the Friends of Arizona PBS, members of your PBS station. Thank you.